we have many distinguished panelists for you to listen to today, and we're going to start first with a couple of short introductory presentations from colleagues, and then we'll go into a more discussion, a more conversation panel session where I'll pose some questions to our distinguished guests, and they'll give us their views, their opinions, and their ideas about what we want to talk about. So first of all, I'm going to ask Tim Stovold to my left, who's a partner at Kingston Smith, accountants who are helping to one of the sponsors of the festival, and just offer him a couple of minutes just to give him his perspective on IP and Futuretech.
Okay, thank you, Adam. I come at this from the UK perspective. So what we see in the UK is, over a number of years, a great environment for developing and holding IP. But it's often the unacknowledged asset within a business where businesses are developing their own IP to deal with their day-to-day problems. And whether that's a computer system or whether it's certain processes or technologies, they often don't recognize within their own business what they've developed themselves. We try and encourage our clients to make sure they actually own the IP they think they own, and what comes as a surprise to many of our Indian clients that invest in the UK is the detail that needs to go into contracts of employment and commercial agreements to make sure that where your employees and contractors are developing IP, they're doing so in such a way that the ownership rests with you, the business, and not something they can walk away with or hold you to ransom over later. When we look at company sales, often ownership of IP is one of the main issues, and whether or not the business thinks it owns the IP, it really does. And once you've established that you do own the IP you've developed, the UK has two great regimes which are encouraging IP research and development in the UK. And then if you're developing something that's patentable, the patent box, which gives a very low rate of corporation tax for profits derived from IP. So firstly, the research and development tax credit. This is a government subsidy effectively for carrying out research and development in the UK. At the SME end of the spectrum, so this is businesses with fewer than 500 employees and the sort of lower levels of turnover and balance sheets. The subsidy for loss-making companies, as often in the research and development phase the companies will be loss-making, is about a third of your staff costs are paid for by government through a tax credit, just over 33% paid by government. And this is a terrific way of funding IP because rather than accepting external investment or struggling to borrow from banks who may not value the company at that point, you're able to have the tax authority, or the government through the tax authority, fund the IP. When you move into profit, the small and medium-sized company scheme will give back 46 pence in the pound tax relief for any expenditure you have on IP, so that makes it even more generous. At the larger end of the spectrum, the above-the-line credit will only give back about 9% subsidy towards your costs. So if you've moved into the situation where you have more than 500 employees, the government sponsors your IP development a little less, but it still can give rise to some very large claims for the large businesses. If you've developed your IP in the UK and you're able to patent something, and hopefully we'll be hearing about patents from my fellow panellists later, the UK's patent box offers a discount from the corporation tax rate in the UK. So gone are the days where you need to go and hide your IP in tax havens. It's not really necessary anymore. What we're looking for here is that the patent box will give a 10% corporation tax rate on profits derived from exploiting IP in the UK. So that the combination of the research and development tax regime and the patent box is making the UK a really, really attractive place to carry out your research and development and later exploit your IP. Thank you.
Thanks very much, Tim. There's some really good incentives in the UK to develop your IP, and thank you for mentioning some of those, and hopefully we'll touch on them a bit later. I'm also delighted to also welcome Mr. Rajiv Agarwal, who is the Joint Secretary at DIPP in India, and I'd also like to thank him for making the journey over from his offices today for us, and he's going to just speak for a few minutes as well. So Rajiv, over to you.
Thank you, Adam, and I must say, even as our lives revolve around technologies, it's becoming more of a challenge to meet them. It took me quite some time to find this location. So I guess the best of technologies can still not uh, provide all the answers, and at the end of the day, there would be some human ingenuity which would be required. Uh, I know you have a great panel out here, and given the fact that I'm sure there would be a lot of questions, a lot of queries that would be coming forth from the audience also. So I'll try and be very brief on just a few pointers, because the topic that we were discussing as we met yesterday also was that even as new technologies and sort of path-breaking technologies that are changing the way we look at society at large, and particular the IP ecosystem specifically. How do we meet these challenges, and how is the government of India looking at them, and how is it looking to meet these challenges? So I'll just quote a few examples out here, because rather than getting into general points, we all know that softwares per se would not be patentable, and the world over it's an accepted view that softwares have to be consigned to the realm of copyrights, and it's only when there's some conjunction with some hardware or something, so that then the patenting regime kicks in. So it's a very fine line to draw where you can go in for patents and where it will be only copyrights. But today, technologies have transcended the very concept, and they blurred the lines between hardware and software. You have fuzzy logic, and you have many more technologies coming in where you no longer can identify something as purely software or purely hardware. And it's becoming increasingly difficult. And I'm sure this is a complexity, this is a challenge which the IP ecosystems across the world will have to meet in the days to come, and they will have to rethink about and redefine the ways they're going to look at the entire patenting regime in this regard. The second is obvious: digital piracy, copyrights. We used to look at CDs, and we could go and conduct raids in some physical market, capture CDs. We could block pirated CDs from entering into the market, from entering into the country. But today, it's impossible. All you have is a signal which gets transmitted all over, and through the digital waves. So there's really nothing that we can do to prevent this piracy in the conventional sense. We have to look at new ways, new means, new technologies to counter the pirates. And this is today becoming a critical issue which we need to look at in terms of the IP system. And for example, there was a mega movie, Bahubali 2, for those of you who've seen it. The producers of this movie got a threat from some person saying that if you don't pay me 50 lakh rupees every day, your movie is going to be leaked online for free public consumption. So when the police got activated, and then they finally tracked down the gang that was active. So just look at it. The movie, the producers are in Hyderabad. The gang of pirates is situated here in Delhi. The movie, the signal is pirated from a cinema hall in Bihar, and it was an original digital signal. So you can imagine the kind of web that they have established, and it's really going to require all of us to be on our toes, to work together to beat this, to meet this challenge of digital piracy. The third issue was obviously Industry 4.0. We have artificial intelligence, IoT, we have blockchain. These new technologies, they present challenges, and yet they present opportunities also. So like the Indian IP office has come out with an expression of interest and has invited offers to see how we can leverage these new technologies in our IP ecosystem and our procedures. So interesting days ahead. We will get to know better. There are obviously issues of data privacy in terms of the new technology. Those are issues which I'm sure do crop up. The issue of standardless essential patents, and how do we tackle this issue, because these are newfangled ideas which were not there earlier. I'll end by some very simple examples how we have managed to use some technology in our working. So earlier, if you were to file for a patent, you would have to go physically to the office in, say, Delhi or Chennai or Mumbai, and go for the show cause hearing, try and explain, submit your papers, etc. Today, you could be sitting, for instance, say in London, and be arguing your case before a patent controller sitting somewhere in Chennai. So you're using video conferencing. You really don't need to travel at all. files don't need to move physically. So the file could actually be situated in Delhi and the controller could be sitting in Chennai and working on it electronically. So there are opportunities and there are challenges. It's for us as policymakers, as industry, to see how we can convert these challenges into opportunities and take things forward. Thank you.
Thank you so much. Thanks to the two sort of opening presentations. I think it really sets the scene of the opportunities, but also the challenges that are available to everybody that's involved in all sorts of creativity and technological growth. And we'll explore some of the themes that we've just spoken about. Some of the themes about how new technologies affect the IP system, how new technologies are managed through the IP system, and how companies take their sort of ideas through to market and help to grow them. So I'd just like to welcome the fellow panelists that I haven't yet mentioned. So first of all, on my right is Miss Pippa Hall, who is a colleague of mine at the UK IPO. She's our Director of Innovation, so very relevant to the talk, to things we're speaking about today, and also our Chief Economist in the UK. Next to her is Mr. Yadavendra Mathur, who's Additional Secretary at NITI Aayog, which is the National Institute for Transforming India. Then Mr. Yogesh Pai, who's the Assistant Professor of Law and Co-Director of Innovation, IP and Competition, so a busy man by the sounds of things, at the National Law University in Delhi. And then to my left, Mr. Akhilesh Rai, who is IP Head and a Partner at AZB and Partners here in Delhi, so a Delhi law firm specialising in IP. So perhaps if I could start with Mr. Yadavendra. We've just heard about some of the challenges we face. What are the sort of the challenges, the issues that your organisation are considering and looking at in the future, and how are they going to try and help the innovation space in India?
Yeah, thank you. So I'd like to compliment the organization of this Futuretech Festival, which is an amazing event. And I'd just like to add to what my colleague, Mr. Agarwal, just now mentioned from DIPP, NITI Aayog, the National Institution for Transforming India, is also driving the innovation ecosystem in India. And we have a mission called the Atal Innovation Mission, under which we are supporting the schools, all the primary, secondary schools in the country, to set up a tinkering lab, and we're funding through a grant process. It's so over 5,000 schools now have a 3D printer, a small robotic kit. So the ecosystem in the schools is being built up. We're also funding incubators. More than 31 incubators have been funded by NITI Aayog. And I think we are also at the frontier of looking at new technology. The National Strategy for Artificial Intelligence, that paper was released by NITI Aayog a couple of months ago. And that's to really leverage not only AI, but other technologies like blockchain and where do we use there for agriculture, for health, for education. So a large number of proof of concepts are being piloted. We are working with a large number of world companies and agencies, and we look forward to collaboration on the intellectual property regime per se. But coming straight down to a very specific comment on the artificial intelligence, because that is something that NITI Aayog is driving in the union. Our union finance minister announced that NITI Aayog will coordinate the work of other ministries. So we are really looking at sharing a lot of big data with institutions and with other partners to how we can leverage the creation of new knowledge, new insights, which will have a developmental impact. So that is where we want a lot of new startups and innovations to come in on agriculture, on health. Like I was mentioning, we're actually sharing a lot of digital X-rays and training the algorithms to detect TB. So we need 100% screening of all Indians, and this is a humongous number. So there are many companies which are working to perfect their own algorithms because the data is available with the numbers. So we're trying to work around what would be the legal framework when the owners of the data and the algorithm owners So how would you share? Who would own? Because even the current legal framework does not really recognize the as a person a machine. So going forward, when there is software writing software, so then what would be the regime? So we're looking at futuristic, and this is where the lawyers come in, and other, across countries. How do we collaborate so that the data can also be monetized, and the intellectual property is also in a way, ramping up the impact, the developmental impact on the bottom of the pyramid. So I think that is the niche area we in Niti Aayog are focusing on.
Thank you so much. So I think that's a really nice introduction and a segue. Perhaps I can turn to Akhilesh and sort of ask him. So that was the kind of the government view, and we'll get a view from an academic sort of view in a second. But how are your clients and the people you represent? How are they using the new technologies? How is it changing both their filing behaviour and their filing strategies?
Thank you, Adam. The one thing that we lawyers have always made money, and especially is that IP owners, which invariably are companies and especially companies where there's a lot of IP, there has been a lethargy of maintaining their IP in a particular form or manner, resulting in them themselves not knowing as to what they possess, whether it can be monetized or not. There's no clear guideline, there's no clear approach as to how to go about, because information is not readily available. Some of my clients who have gotten into using blockchain, for example, they have managed to streamline the processes, starting from creating evidence of use, which at times can be very instrumental in any kind of infringement or passing of actions, arresting counterfeiting, ensuring that if there is an employee who has created something, so employee theft, which as of today in most of the tech companies is one of the biggest concern. They spend huge amounts of money for internal forensics and things like that. So with blockchain being used by these companies, one, for any development, additions, changes to the technology, the drawings, the write-ups, creating documents, one, it's time-stamped, and there are some people who authorize, one person to access only one machine to log in, and therefore the name also crops up as to who was the last person to access the particular document. And thereby, there's a complete chain of event that is created without them spending a lot of time, energy, and money on having people physically look up. There could be human errors, they could lose out on certain critical information, and unnecessary. Like the second aspect, especially in patents that we see, once I've got a patent registered, I may or may not have any use of it. There could be several advanced technologies that have come in, but still I'm spending money for renewals. Now that money that is being spent, if I have the entire data as to whether this particular product is being sold, what is the sales, whether I need to discontinue it, whether I need to renew the patents, or probably then give it out for commercialization purposes. So there's a something which was scattered has become more linear, and it's actually saving companies on costs towards maintaining their IPs, enforcement activities. And one of the most interesting thing is that nowadays with companies especially who are in development, R&D, with they are very excited about big data coming in, where there could be certain triggers which would give you information from all over the world, not necessarily whether a patent is registered, but it could just be a prior art which is not registered but out there in the open. So rather than spending money on drafters, researchers, filing of application, by which time they've already spent a lot of money only to come to know, well, whatever they were doing is of no worth. So I see interesting times as far as IP and technology going hand in hand, enhancing the viability of any kind of innovation, reducing costs, and generating more revenue for the company.
Thank you. That's really interesting, and I think links nicely then. So we've heard about sort of where the government is going. Obviously the government can shape behaviour of industry, but also has to take account of the behaviour of industry. And knowing that the technology is already in use and is already being activated is really important. Governments, I include all governments in this, and governments often move quite slowly, and sometimes in legislation, and often business behaviour has moved faster. So do you see that as a similar challenge?
See, the thing is in India, and I must credit Mr. Mathur and Mr. Agarwal and team, there's been a marked change as far as the IP offices in India are concerned. So not more than 3 years ago, 4 years ago, trademark to register could take about 7 years. Now, with the use of technology, trademarks get registered in 6 months. So that's the fastest anywhere in the world. Even in the US, it's with the opposition period and everything, it can take something about a year. There are certain concerns which, as practicing IP attorneys, we do face. As I said, there's marked improvement as far the functioning is concerned. But I think, the future technologies can be put in better use as far as the IP offices are concerned to determine, if most often than not, what happens is, for example, I need to show prior use in a opposition or infringement action. The thing that I could have probably is a brochure. I may not have actually launched my products or, a patented product into the market. Now, in that intervening period, we all know that, a company, there's a lot of time gap that takes place between development and actual launch in the market, within which time there is a possibility that somebody else may have, come to know about it, adopted it. Now, do I lose because of somebody was, looking out for something? No. And in which case, big data and, technologies such as blockchain can come in handy. And, I think the offices should develop themselves through acknowledging these as evidence as well.
Thank you. So let's think from an academic perspective. So I'm sure you've seen many challenges to the legal ecosystem, and I think we've already heard some of the areas where that may take effect. But what's the view from sort of the universities and the people studying these issues?
Thank you, Adam. What a fascinating time to be, in. 2018 is exactly 10 years after India unsuccessfully tried to introduce a version of BIDOL, Indian BIDOL, that was in 2008. And it had several problems, and that's why the Parliamentary Standing Committee, actually made a lot of amendments, and then the bill was withdrawn into 2014. But nevertheless, there are so many fascinating developments that have happened in the last decade or so. And if I come to think of some of the most immediate legal challenges, I would like to see it from a four-dimensional perspective. One is we have a good ecosystem for IP from a research incentive perspective, but not so much from a commercial development perspective, and I'll come to it. And then we have geopolitical and access-related issues in the context of tech transfer. We also have regulatory kind of issues that would involve competition law or some kind of other regulation involving Biodiversity Act in the context of agri-tech and other areas. We also have new challenges because of open and closed models of innovation and how tech transfer happens in those kind of environment. So let me go through the first one, that is tech transfer and commercial development and the need for a different kind of an IP ecosystem. One of the first things perhaps that comes to my mind is lack of data protection in the sense of data exclusivity. In one of the meetings that I was told in the Department of Petrochemicals, Chemicals and Petrochemicals, the IPFT, that is the Institute for Pesticides Formulation Technology, and also the Indian Agricultural Research Institute, both of them expressed their concerns that if they provide non-exclusive licenses, then one among the non-exclusive licenses does not have the incentive to take the molecule forward or take the invention forward to actually commercially develop into a product. And this is precisely for the lack of effective data protection, test data protection in the country. Second is a lack of a codified trade secret protection regime. We have common law protection, but if you look into the standards of protection, especially for example non-compete clauses, which is very important in relation to preserving your tech, and it also involves a lot of tech transfer issues. There are two contrary Supreme Court decisions, and there are issues with reference to what kind of standards you would follow in case of because our courts are essentially remedies oriented. So you have an interim remedy granted, but the standards of protection in case of non-compete clauses, especially the reasonableness clauses, have not been reconciled in two Supreme Court judgments. We also have issues in with reference to third-party liability in the context of breach of confidence, where some standards have to be settled down. And perhaps in that regard, I think the national IPR policy indicated that we should perhaps look in for doing some studies, or at least find out ways to ensure effective trade secret protection. The second kind of issue that comes to my mind in case of tech transfer is the use of Essential Commodities Act to enforce tech transfer, especially when the contracts are terminated. And this has happened in the agri-tech environment, especially the current sub judice decision in the Supreme Court, where you would see that the division bench of the High Court has effectively used the Essential Commodities Act to ask one of the parties to continue to engage in technology sharing and sharing the donor seeds. And this, to my mind, is one of the other issues that affects the legal kind of ecosystem involving tech transfer. In terms of the regulatory environment, what is interesting in this a new context is again at least there are a couple of investigations that are currently pending at the Competition Commission. We will try and look into boilerplate provisions, and boilerplate provisions are very essential in case of tech transfer contract, and certain kind of boilerplate provisions have been challenged in the context of investigations that are going on for the abuse of IP. So perhaps we need to take a second look into those kind of prima facie orders, and then when the investigation is completed, perhaps we'll have more clarity on what it means to have a kind of regulatory environment that inhibits or impedes use of boilerplate provisions in the contracts. Then finally, on open and closed source models. Now, what is effectively happening in certain areas? For example, if you look into standard essential patents, the tech transfer is happening through standard development organizations, or SSOs. So the diffusion model for certain kinds of technology is not exactly through a contract model that you would anticipate, where there is a lot of confidentiality attached, but it happens at a very high level at the standard setting organizations itself. And what I have found through my own experience and talking to people and looking into data, India's participation in these standard setting organizations is very, very minimal. It's only with the formation of the TSDSI that we have started participating. But from my understanding, universities should often participate, because there is a lot of tech transfer that goes on in terms of absorption of technical specifications and how technical specifications are formulated at the standard setting organizations. Also, with the rise of digital platforms and two-sided markets, I think the entire ballgame of how IP is looked at from a tech transfer perspective is going to change. Because the models in which two-sided markets operate are largely open models. So with this, four kind of challenges, I think we need to think about the legal frameworks appropriately, and how to actually try and ensure that it's not just the research incentive, but also the next part, that is the development part and the commercial development part, and a legal ecosystem for that is taken care of.
Thank you. And there's certainly been some innovative and interesting cases on standard essential patents and the FRAN model in the UK legal system that has had where judges have taken a worldwide effect. And I know that's we don't have time to debate that today, but certainly I think in the various debates in law firms and law societies we'll be discussing that in great detail. So it's a very important point. So if I can look to Pippa, I think what we've heard, perhaps with your chief economist hat rather than your innovation hat for the moment, certainly as policymakers we know that sort of the facts often are the things that sway the politicians. It's what makes a difference are the numbers. How is the policy going to affect people? Economics and IP are often quite challenging, so perhaps if you could give us a feel for the difficulties we face in that, and perhaps how either big data or other technologies can help us sort of fill those gaps.
Yeah, thanks, Adam. Yeah, you're completely right. I think quite often we get asked for evidence and data on why IP is important and what the impact of a potential IP change might be on technology. And quite frankly, we don't have the data to do it, and it's often very tricky. And I think, numbers are important. I remember being asked when we were making some of the changes to our copyright law, so what's the next new technology? And my answer, quite frankly, was, well, if I knew what the new technology was, I probably wouldn't be sitting here as a government economist, and I'd be making my fortune elsewhere. But you need to be able to demonstrate that impact. And so I think, for me, I'm excited by the opportunity that big data and some of the new technologies around blockchain have on how we might be able to get better data in the future. And the other day we were talking about there's a lot of interest in IP and trade and what that looks like in the future. And we don't have the data to understand what's really going on when it comes to IP and trade. But actually, I was talking to some data scientists who said, well, we could start to merge all of these data sets together and you kind of do technology scraping. And that starts to sound really exciting, so that actually we can get the numbers and start to demonstrate that IP is fundamentally really important. But I think, and we might touch on this a little bit later, but I'd also stress that it's not just about the legislative framework. So switching to my other hat, it's really important that we make sure that we've got the framework and the environment around it so that the IP can really have a real impact. And if we want these technologies to grow, then we need to make sure that that environment is fit for purpose.
Excellent, thank you. So a real call to arms there for everybody to make sure you get your numbers out. And certainly the UK spends a lot of time looking at the issues Pippa's just talked about and conducting studies. And I think one of our messages across the world is where we can collaborate on non-political, non-legislative issues, so where we can better understand global trends. IP knows no boundaries, certainly, and this is a fantastic demonstration of that, and how we can use data from as many countries as possible, because obviously that makes it more stronger and more usable, so that's really important. Thanks, Pippa. So Tim, I know you're not sort of an IP specialist per se, but some perspectives that you touched a bit on in your opening conversation. Listen to what you've just heard about in general terms, and you advise businesses on various elements of tax planning and IP. Is there anything you wanted to sort of add on the pitfalls, perhaps?
Well, the observation we have of our clients is at the time they're developing their IP, every last pound, dollar, rupee is thrown at the development, and that's the time we say, look, please go and see an IP lawyer so you can talk about protecting what you've got. And it's one of those problems for tomorrow. We'll go and protect it once we've got some revenue, and that's a second priority. But the stressing to our clients and anybody developing IP to think about protection sooner rather than later, and not to be put off by the cost. I was delighted to hear that India can register a patent in 6 months. I think that's a land speed record. I think the other point that came across is that the later commercialisation, and I was just thinking in my mind about how what the barriers are to financing later commercialisation. The tax incentives I mentioned, I won't go over them again, but that's some way in which some of the businesses will fund their later commercialisation. They may do equity fundraising, and the UK's got a good ecosystem for fundraising at the small and medium-sized end. But the sad truth is that many companies that develop IP and can't finance possibly the multi-million pound spend that's needed then to commercialise it are exiting too soon. And you've got the true risk takers who are putting quite literally their lifeline on the line here, exiting too soon, selling possibly pre-revenue for a low valuation to big business who can develop the IP. And what we'd really like to see is an ecosystem where once IP looks like it's got business viability, there are routes to finance to make sure the risk takers can actually benefit from more of the rewards.
Thank you. It's almost if we rehearsed it, but that was an excellent segue into the second half of the session. I'm conscious time is running on, but we have about 15 minutes left. So we wanted to think about tech transfer and commercialisation, and exactly the point you've just talked about, and how challenging it can be for people, and how so much IP or so much knowledge is sat around in sort of patents that are never used, even in really big companies with really sophisticated IP management sort of portfolios. So perhaps I could turn to Narendra again and perhaps ask, how does government help to take this sort of thing forward? You know, are there any specific policies, certainly that the Indian government and your own organisation are looking to help people in either tech transfer or the follow-on commercialisation of products?
Yeah, so now, while the Ministry of Commerce and Industry, they have the specific interventions, but the Niti Aayog, which I represent today, we are supporting the innovators, the incubators, sorry, and we're encouraging the state governments and all stakeholders to connect with us and show the proof of concepts that they have, and then we can actually then handhold them, connect them to investor communities, and we keep facilitating that interaction. But otherwise, we are not putting money on the table through any specific program yet. But I think the funding is available for incubators, really. So we would really encourage some of these early stage, breakthroughs, because we are more looking at blockchains and AI, not going into very conventional, for which there are other specialized. We have the ministries, then they've got specialized personnel. Niti Aayog, my organization, we're only looking at blockchain and AI, and we're trying to push the envelope for in these areas, not the where we feel there are a large number of agencies in India which are supporting. But having said that, the Make in India, and many of you would be aware of this national commitment, that is really not only Make in India physically, but to actually generate intellectual property. We keep sharing stuff about how an iPhone in manufactured in China, it's only about $175 for this is about 4-year-old figure. I used to be chairman of India's Export-Import Bank, and so I used to know what's going around, and the kind of valuation which is available for the IP, and that same phone for which about $168 is the input cost if you took everything in, and about $7 is the manufacturing cost, and then the $325 markup when it sells for $500 is all design, and so the real value capture is in monetizing your design, your product, and I think that's the message which we are now trying to push through. That don't bother so much about actual physical manufacture, get into the patents, work more closely with the design community, and get the lawyers to support you, and that's where the real manufacture is. So I think that narrative on Make in India has got kind of garbled, in my sense, as if it was only to get a design for somewhere and physically set up a factory. I think that message is now gone out, and you can see the results in this, and that's where India's growth rate is bound to accelerate. So I'm pretty satisfied with the ecosystem that's already been built around, but we could definitely learn some more techniques of particularly the lawyers. That's where we think the facilitation needs to come. The transaction cost has to be brought down on the documentation and the filing of the patents. I think that's one area where we would like to go ahead.
Excellent. Now, I think there are some people with microphones in the audience to help you out. So I do want to leave. I've got one more question, but I do want to leave a bit of time for the audience to ask questions. So we have about sort of 5 or 8 minutes. So please think of some really difficult questions to ask the panelists, because I won't be answering them. I'll just be repeating them, so that's fine. But before we do that, just if I go back to Pippa, actually, I mean, we've just talked about sort of commercialisation and the challenges and valuation of products. There's some quite innovative work in the UK going on, so perhaps you could talk about that for us for a minute or so.
Yeah, very happy to. As we see economies changing, so businesses now have a lot of intangible assets, they don't have the tangible, and they need financing. So we've heard a lot about how expensive it is, how timely it is to make sure that they protect it, and how they grow their business. And so one of the things we're trying to answer in the UK at the moment is, so how do we let those businesses that are IP rich get financing on their IP asset? But to do that, you need to value the IP, and that's kind of where the problem lies. So the very nature of a patent is that it's new and novel, so there's no market comparison. And IP valuation is incredibly expensive and incredibly opaque, and quite frankly, the banks don't trust the valuations that are out there. And so, we see that if we really want to encourage this innovation and this growth in the UK economy, we need to fix this problem. And so we're doing some work to launch a valuation pilot to when a small firm is taking out a loan, not based on the IP asset itself, but we're paying for the firms to value their IP, so that we can start to build up a database understanding what happens to the value of the IP over time. Because the value of your patent, for example, on day one will probably be very different to the value of your patent if you're in trouble. And we need to kind of build that profile of valuation over the time, so that banks can understand the risk profile that there is associated with that. And so I think this is really exciting, because if we can build up the database of IP valuation and demonstrate, as we've already started to do, that actually firms that have IP are far less likely to fail than firms don't. The economist in me says you have to be really careful about causation and correlation, but part of that is just around businesses that have IP have good management structures, they have good business plans, but actually that means that they are a good bet for the banks if they have the IP. And so if we can build up this profile, we can get the banks talking, understanding the IP valuation, then I'm really confident in the future that we can find financing schemes that allow IP-rich businesses to get finance on their asset and then to continue to grow. So it's exciting, watch this space, and I know we've been having conversations while we've been over here to see what we can share with the Indian government and think about how we collaborate going forward.
Excellent, thanks Pippa. So I want to throw the mic open to the audience. Obviously we're concentrating on sort of future tech and IP and commercialisation and technology, but please ask any questions that you have burning. I can see a gentleman ready to go, so over to you, sir.
Am I audible now? Yeah, thank you. My question is to Yadvendra Mathur. See, in India, IP is being seen as a major collateral for growth and investment and for competition too. But I have not seen anything happening from the side of the government as far as, valuing the IP, as she rightly mentioned. We have not seen any initiative from the side of the government, to consider IP as a major collateral. It does not even come into the balance sheets. And no loans are being provided, no insurances are being provided to the IP. I know there are several intrinsic limitations as far as this kind of component is concerned. But I just want to hear what Niti Aayog, if it is considering it at all. So what is the steps that Niti Aayog is taking or DIPP is taking to consider IP as one of the major collateral for growth and investment?
Thank you.
Absolutely right. This is an evolving area, and typically government policy cannot force banks to, because they will perceive any lending operation from their own prism. So typically it is not really a policy-driven mandate of how you value an IP. It has to be, like Pepper was saying, you have to build up the data, and that's what the bankers need. So, for example, I'm sorry to sound, but
typically retail bankers won't lend to lawyers. They'll say, oh, if if I was a banker, I'm sorry to, but this is the kind of mindset a banker may have. That if you're giving a loan, don't give to a lawyer. So that's like a prejudice. So I'm absolutely clear that there are prejudices like this even around IP. Because the bankers are also groping in the dark. And they really don't know how to monetize an IP, even if it were there, and because the valuations are where the whole challenge is. So there is there's no specific strategy other than to keep disseminating the data. And it's, let's say, the CIBIL scores. Many of us use credit scores, and now there are 4 or 5 credit agencies from which there is a public credit, and the bank, and that's what the government or the RBI has mandated that you got to share. The banks have to share the data. Now we're talking of a public credit registry in the country, so that anybody, so it's not only with the private sector, but there's a public credit registry. So similarly, maybe in the future when these patents or there are more sophisticated techniques to start putting a value to a patent, bankers would lend. So I'm sure that it's but there is no clear policy as of now.
Thank you. Very clear answer. I think the gentleman or lady over here was first, and then I'll come to you. That's it.
Yeah, sorry. The main issue is also the challenge it is to translation of the patent or designs which have been registered into the actual products. Because what happens is even the small companies, if they purchase or buy or get the license, they are not capable of developing it into a product which is commercializable. So there is a need in India to look at it this aspect also.
Thank you. Is there anybody want to make any further comments on that, or I'll pass on to? But thank you for your point there. Let me just go to this lady first, and then to you, sir.
Hello. Oh, hi. Apologies if you've already covered this because I arrived late. However, I am on the the UK side, and I'm interested in Indian companies' perceptions of coming into the UK. And my question is about what is the perceived attractiveness of the tax incentives for patents or R&D? Is it useful? Could it be better, or is it attractive? What's your thoughts?
Thank you. So Tim has covered it a little bit, but sort of a perspective on the company's perception, and perhaps Akhilesh as well. I know you do business across both, so okay.
Well, I mean, some of the largest claims we do as an accounting firm are for Indian software service companies, and the UK tax authority is very comparatively easy to deal with on these claims. Very few of them get challenged to any material extent. So I think at the very large end they are used. If you're the very largest of the software service company with thousands of people in the UK, they're incredibly beneficial. If the Indian companies at the smaller end of the spectrum have got to look at whether carrying out research and development in the UK at a UK cost with the tax incentive compares favourably to carrying it out in India, where there's a lower cost of carrying out the R&D, perhaps with less tax incentive. So at the smaller end, we see the SMEs, the small and medium-sized businesses, taking less use of the R&D scheme. But at the larger end, it's been brilliant. The patent box I've seen less used by Indian companies. I mean, largely my experience is software, and as Rajiv explained, patenting software is not impossible but difficult, and so that's not used, but it's early days for the patent box. But we still promote it. It's still tax incentives seem to appeal to most people, so it's good.
So Akhilesh very kindly reminded me he's not a tax lawyer, but I mean, perhaps a perspective on sort of the attractiveness of the UK IP regime and market for Indian businesses. I know you do some cross-national stuff.
The thing is, I experienced, like I'm an IP lawyer, but so sorry. Hello, can you hear me? Yeah. So I'm basically an IP lawyer, but I've been involved in a few M&A deals, and the little that I can talk about, especially as far as innovation is concerned. The problem in India is if I'm an Indian sitting in India, I innovate something, I need to take permission from the patent office to have it registered in a foreign territory or start using it in a foreign territory. And therefore I think, to overcome this hurdle, there are possibilities, and I think the Indian companies could consider, having their R&D, outside of India, where they can file for patent grant, which as of today in India is slower as compared to most of the other countries. The enforceability aspect is slower in India as compared to other countries. So I think there are chances that people may want to, and most of the MNCs, for example, although they have a lot of R&D going on here, but since the instructions do come in from the US or the UK, chances are that they would want that the patents be filed in those countries, and exploitation start there and then followed with India.
Thank you. Any more questions? We've got about 3 or 4 minutes. The lady at the back. No. That's it. Thank you.
Yeah, good afternoon. The data protection regime which has recently come in the UK and EU, from an IP perspective, and when we're looking at future tech, the concerns with data protection will grow. So if someone could just share a couple of perspectives, also whether the government is looking into bringing in any sort of policy in this regard as well, and the UK perspective?
So I'm not a data protection expert, but I'll try and attempt to talk just a little bit on the UK. Yeah, so from a UK perspective, it is a new regulation. It's very large and very all-encompassing, and it has posed challenges as businesses of all sizes and varieties get used to the regulations. I think the policy aim is absolutely valid, and I think the need in the modern world to have ownership of your data to a certain extent is incredibly important, and certainly there is a crossover to IP, and particularly as we move into big data and some of the biometric type stuff where people's wearables and all these sorts of things. So I can't answer your question directly because I say it's not my area of expertise, but certainly it's an emerging, as with all these things, the regulation says kind of operates in a vacuum to a certain extent until it comes into force and people actually use it for their purposes. So we recognise the challenges at the interactions and intersection with IP law, but we're kind of seeing how that plays out, and in due course, I guess policymakers will consider that. But did you want to say something? Yeah. So watch this space, but it's recognised as an interesting point of IP law. But as I say, I think very much recognised also the necessity for it to happen. I could take one last quick question, if there's anybody else. Or maybe that's a perfect. Go on.
Well, if
No,
I
absolutely.
just,
go on. Yeah.
reply to Professor Chaturvedi's comment on tech transfer. I think the problem in most countries and even in India is that tech transfer offices, TTO offices, are not seen as a cost. And unless you see that as a cost and include that and budget it, you wouldn't get good companies to develop your technologies. So what happens, from what I have heard from people who work with tech transfer offices have to often justify their existence in a public university. And if they have to justify their existence, then their existence could only be justified after a successful licensing program. And it's like a chicken and egg story where you end up with not having the right set of companies to develop your product. I think focusing on TTOs and budgeting them as a cost essential for enhancing public welfare, I think is a good way to understand the role of TTOs. I think that would answer the problem of lack of commercial development.
Thank you. Any more comments? No. Thanks, Yogesh, and sorry for not bringing you in on that question. So really, it just remains to say a big thanks to both Mr. Agarwal, who's had to run off to another meeting, but also to the rest of the panel who gave so freely of their time. I hope it was interesting. You've been listening to Futuretech IP. I have to look at my notes now. Turning ideas into impact. So I hope it's given you some food for thought, and you've enjoyed the session. So thank you very much to everybody. Thank you.